So it's an NMD.
It need not be an MD, my lords. Let it be any Monday. I respectfully submit.
Monday week.
Grateful, my lords.
Monday we could be holiday, I think.
Any myth, my lords.
Holiday, so 21st को कर देंगे.
So this is a civil matter. The next tentative.
Not to be delayed days.
Your Lordship, it is the NMD. The next date shown is as NMD 23rd of April. Your Lordship, it is a short matter. It may be kept on a miscellaneous day the next coming Friday. After that.
I'm appealing for 1 to 4. I need some time to file counter.
So let it be on 23rd.
Okay.
My lords, say including application filed in the Udavaram forest matter, any date matter.
16th.
My lord, I am for the state in this matter. My lord, I have already filed my counter affidavit. My apologies, I physically am unable to come today because of fever. My lord, the counter may not have reached to lordship because recently it has been filed, my lord. Have it on next Friday, my lord. By that time, the counter.
1 minute.
Sorry. In 810, there is a second matter, which is an idea related to Hazaribagh bench. That may also be listed in it.
Lords, my lord's permission, may I mention item 58 listed on Monday? My lords, this is that contempt, Kushinagar demolition, loss contempt. I appear for the district administration, my lords. Lords, I am in a personal difficulty on Monday. I have spoken to the other side. They are the petitioners. They are also available also online. They have consented to a short accommodation any day, my lords.
Who is happening for the petition?
Mr. He's there.
My lords, I am appearing on behalf of the petitioners, my lords.
I have a personal difficulty.
Yes. Any objection, Mr. Counsel?
No, my lords. We don't have any objection. My lords, may kindly list the matter on any miscellaneous day.
The request is 25th, but I think all the miscellaneous days are holidays. It may be 25th. My friend is also amenable to 25th. I've spoken to him.
25th is a Friday. Don't keep any heavy matters on Friday.
The next Monday, as in I am any day.
Yes, Monday we don't mind, but not Friday.
Plus, can be the following Monday after 25th.
Okay. Yes.
I am very grateful.
Grateful, my lords. Grateful.
On this matter. Meanwhile, the pleadings can be. I am filing.
You are happening for whom?
I appeal for the Nagar Nigam.
So who has demolished? Nagar Nigam or state?
I respect your concept in the matter.
Yes, sir.
Beyond the sanction plan.
What did it be? If you have breached it, then whether Kushinagar has a central prison? It's, I think, near bordering Nepal.
Yes. Bordering Nepal.
Yes.
Grateful.
May I please, Your Lordship, allow me to one IA acknowledge that is the implementation application which is filed under SLP 4799 of 2022. Recently, in this matter, my lords intervened. My lords, this is a matter of students' merits.
So what do you want?
My lords, that is urgent listing merits. Date is not showing. IA is numbered merits.
Please, my lord, I am for the state. My lord, I am for the state. My lord, I have already filed the counter affidavit in the matter. Recently, my lord, have it. It might not have reached to lordship's file, my lord. Have it on some other day, my lord.
Whether co-accused has been granted anticipatory bail by the High Court?
Yes, my lord. Even your lordship's order dated 24th of January 2025.
We have granted him, but we have granted him since the High Court has granted the co-accused.
Yes, my lord. But at the same time,
the charge sheet is filed.
My lord.
Since the ignored I'm assisting your lordship. In this matter, your lordship, the difference is that the petitioner is the person against whom the main accusation is when a body grievance heard. The order by which the co-accused have been granted bail, that order clearly specifies that the main or the main.
So show the FIR.
May I submit my friend just they filed an injury report. Because the allegation is that I hit him on his head. Now the injury report they filed, it's the back portion has been.
Well, let us say the FIR.
My lord, it starts from page 15. The relevant portion is on 20th page, page number 20, my lord. May I read, my lord? The prosecution case in brief is that the informant Tulsi Mato alleged inter alia that on 13th of May 2024, informant along.
You're reading page 20?
Yes, my lord.
Yes.
My lord, on 13th of May 2024 at 9 a.m., informant along with the brother stated that his grandfather is the Khatiyani Raiyat of so and so. This is a land dispute, my lord. On the said land, this informant was going where 10 to 12 persons were along with the intention, my lord, with an intention to take possession, constructing wall. When the informant party asked why they along with the others were doing the construction, as the matter is sub judice before the Honorable High Court. Thereafter, accused persons sustained.
When was the FIR filed?
My lord, FIR was filed on 16th of May 2024, my lord.
Take into consideration the fact that the co-accused has already been granted identity bail by the High Court, and that after the interpretation granted in favor of the petitioner has joined the investigation. We are inclined to allow the application. The ordered response is confirmed.
My lord, my counter affidavit may be taken on
Whereas
record.
the state vehemently opposes the application.
Obliged, my lord. Deeply obliged, my lord.
May please also. Wants to withdraw the petition. If they become infectious, the petitioner will release on 26th.
The learned counsel of the petitioner is liberty to withdraw the petition. Dispose of as withdrawn.
And it's fresh. Almost all the accused except one after your lordship's order releasing the other two accused on bail have been released on the High Court notice.
It's a notice. Returnable 4 weeks. So the petition.
It's a concurrent finding, my lords. Only endeavor is, my lords, can there be any mediation, my lords, because
Both wills have been disbelieved. Everybody has been granted share, equal.
but there was some third.
Thank you. It's going to your brothers, sisters, still you are fighting here. Yes.
I was praying for an adjournment. My learned senior had a family exigency and he was unable to travel to Delhi today. I'm just praying that it will be next week. Please.
कौन है? Very person.
Sir, I am here against the lodgement of my contempt petition. The reasons given for lodgement, Your Honor will find on page 21 of my petition, my miscellaneous application. And in my respectful submission, all those 3 reasons are wrong. Your Honor will see page 21 of my application. The learned register.
What is the contempt according to you?
The contempt is I have filed a petition in the Bombay High Court, which is of public interest nature, and it seeks to recover 77,166 crores of monies for public causes. And during
what is the contempt according to you of which order?
Sir,
according to you, which order of the Supreme Court has been violated by the contempt? You just tell us that.
Order of the Honorable Supreme Court is on CA 440441 of 2020.
Have you annexed that here?
I have annexed it in my 39039.
You have a contempt petition.
It is on page 103, 100.
Hundred
103, sir, para 19.3 is the extract from the relevant judgment. The last line, sir, on page 103 is the Honorable Supreme Court has said, but what is required of a director nominated by a charitable trust is pure, unadulterated public interest. Therefore, there is nothing abhorring about the validity of affirmative.
Bro, what is the contempt according to you?
Sir, that's what I'm coming to. The Alice.
Are you party to this list?
Sir, I was a proposed intervener, and therefore I have applied for permission to file this contempt petition. The problem is, sir, I was offered 50 lakhs to withdraw my,
We are not concerned with that. You file a police complaint. Yes, thank you.
sir,
Dismiss.
sir, at least.
Thank you, Mr. Khan. You go, please.
Please, your lordships.
Yes.
Item 7, I'm requesting for a passover. I'm being led by a senior man.
Already complete, I'm telling you.
Let him come.
Yes. Please, Lords, in this matter, a primary prayer before the High Court was decided by pending application, Lords.
After how many generations you have?
I am aware, Lords, that is
55 years.
of delay, Lords, but the compensation amount.
10 years less than what I am doing.
Lords, High Court has not considered two very important provisions of.
Thank you, sir. बीस साल के बाद आ रहा है पाँच आते बाद में ठीक
Lordships, Order 141, Order 41, Rule 33, first appeal has been decided without when they give their decision. And the other feature of consequence, Your Lordship, is that there are two suits which are filed. One suit in
You tell us from the trial court order as to how the trial court judgment is wrong.
Yes, Your Lordship.
Forget
Your Lordship,
about
we straight have the issues which have been framed by the trial court. The issues have been framed at page 130. There are 7 issues.
130.
113, 113, 114. 113, 114. And Your Lordship may note that this is the second suit which has been filed. The first suit was filed, this is a suit of 1981 in which the issues have been culled out. And the first suit was of 1978, Your Lordships. In the 1978 suit, they had first sought the fact that they want a permanent injunction. Then they moved their amendment application saying that I be restrained from any monetary consideration.
Which is the issue you want to press now?
Yes, Your Lordships. Now please come to the issues which are here, Your Lordships. 5 and 6, Your Lordships. Whether, if Your Lordships have page 114, whether the suit is filed representing the general public and for want of adopting required process, the suit is not maintainable. Second, whether this is a second claim filed by a plaintiff, and prior to this, their earlier claim is dismissed, so this suit is not maintainable under Order 6, Rule 6 of the CPC. On both these determinations, Your Lordships, the learned First Appellate Court, the High Court, they passed no decision.
What is the reasoning of the trial court on these issues?
Yes, Your Lordship. The reasoning of the trial court on these two issues first deals with the fact, Your Lordships, that the 1978 suit and the 1981 suit are distinct suits.
Let us see whether the finding is wrong or not.
Yes, Your Lordship. Your Lordship may have the preliminary decree which is passed on issue 5 and 6.
Give us the findings of the trial court on this.
Yes, Your Lordship. Just to give context to that, Your Lordships, may I just request Your Lordships to have page 64 and 66, which is the preliminary decrees in the matter, wherein page 64 and 66, para 10, that from perusal of both suits, it's clear that in both suits, cause of action is different because in first suit, violation was made of order of Gram Panchayat by the defendant and present suit is filed against said objection. Said situation was not raised at the time of filing of first suit. Cause of action of present suit is raised after filing WS by the defendant in earlier suit. So cause of action is different from cause of action in earlier suit. This is one finding, and the other finding is available, Your Lordships, at para 7 at page 64. Pertinent to say that earlier suit of plaintiffs was dismissed due to non-appearance of plaintiffs, so it cannot be said that suit was dismissed after making hearing of plaintiffs on the merit of the case. So this suit is not barred by the doctrine of res judicata. This, Your Lordships, is a direct violation of Order 9, Rule 9, Your Lordships, wherein if a suit is dismissed for default or a suit is dismissed for non-prosecution, then decree against plaintiff is by default bars a fresh suit. if you're not on the same cause of action, Your Lordships, please see Order Rule 9. Order 9, Rule 9.
Please come to page 11.
Yes, Your Lordship. Impugned order. One moment.
One
One moment, Your Lordship. Yes, Your Lordships. Page 11, Your Lordships. Page 11, second paragraph. Sorry.
You will be finding it. Special notice.
I'm seeking a stay.
Status quo position.
So deeply grateful, Your Lordship.
Notice readable for 4 weeks. Justly permitted. Status quo position till next day.
I may also be permitted service by publication, Your Lordship, because there's several parties in it, Your Lordship. Grateful for an extremely
Substitute service by paper of publication is also permitted.
Please, Lordships. It's a suit for partition, Your Lordship. The petitioners here in defendant number 4 and 6.
Where were you living? With your adopted father? Sorry, adoptive father or your natural parents?
My Lordship, in fact, I moved an application of place on record, additional document for the High Court. In fact, that's not been taken into, say,
nothing.
On record, Your Lordship.
Thank you.
My Lordship, I at least appreciate to say the fact as far as the schedule number 10 is concerned, I continue to live over there. My Lordship may see the observation made in paragraph number 24. And since each one is entitled to 1/5 share, let me at least, okay, that portion can be apportioned to me. My Lordship may have page number, say, 32 for a moment, page 24.
Whatever you get from your parents, will get it.
My Lordship, no, in fact, the court also observes that in my favor. My Lordship may have, let's say, page 32, paragraph number 24. Learned Counsel for the appellant submits that the appellant number 2 is residing in item number
Page
10.
number?
Page 32. 32 of the impugned order, Your Lordship, paragraph number 24. Learned Counsel for the appellant submits that the appellant number 2 is residing in item number 10 of the suit scheduled property. He prays that item number 10 of the suit scheduled property be granted in favor of, say, defendant number 4. His submission is placed on record. Liberty is reserved in favor of, say, defendant number 4.
So that you can, in the execution position, you can always, we are not inclined to entertain the present appeal petition arising out of concurrent findings of fact. In any case, insofar as the property, that is item number 10 is concerned, the appellate court has already granted liberty to the petitioner to work out his remedies in the FDNP proceedings. The executing court would consider the same in accordance with law.
My Lords, in item 12, I beg to appear for the petitioners. My Lords, in this case, before the learned single judge.
After selling off your
Lords,
what right you have in the property?
My Lords, I took a specific plea in my counter affidavit filed in response to the writ petition before the learned single judge, which is at page 186, that the sale deed was without consideration. Now the learned single judge has not considered that, my Lords. The division bench also considered
the revenue entries do not bestow any title on the parties.
Lords, the pivotal issue was whether there was consideration received by me or not. That is not
for a revenue court to decide.
No, that is right, my Lords. But at the same time, when they were seeking issuance of directions to the revenue authorities to effect mutation, my specific objection was that since there is no conveyance of title, there is no justification for the prayer to be granted. Now that issue has not been
conveyance or not. Are you disputing the conveyance?
Yes, my Lords. I had specifically stated so at page 186, my Lords.
It is a conveyance without consideration.
That's right, my Lords. I have said so.
You are not disputing a conveyance.
No, my Lords. I am also saying if your Lordship sees the sale deed.
File a suit. Yeah, dismiss.
My Lords, then your Lordships may grant me the liberty to file a suit.
Dismiss, however, it is clarified that in the event, the petitioner, since the present petition arises out of the orders arising out of proceedings for entry in revenue records, we are not inclined to entertain the present petition. If the petitioner has any grievance with regard to title to the property, the petitioner would always be at liberty to make recourse to such remedy as is available in law. If
I'm grateful.
the recourse is taken, the findings in the impure orders would not affect such proceedings.
Grateful notes.
I can't, my lords, urge before your lordship that there is a fault in the High Court's order, my lords, but I can inform and assure your lordship that we have instituted an inquiry against the earning officials. This is indeed a case, my lord, where the land, this land was acquired for road constructed since 2014. When they filed the writ petition for the first time in 2021, they themselves award that they have been given 25% of the amount. Now, my lords, the new under the new act, the compensation has to be, my lords, fixed and a new process has to undertake. Then, my lords, the quantum is very, very different, my lords. It will be a huge amount of public money that we will have to lose because of some, my lords, folly of the officials involved. So, if your lordships will permit me, two things, my lords. One is that this inquiry we have instituted.
What is the inquiry?
My lords, we've constituted a committee for. Because tentative award was also published in 2012. 25% of the amount was paid. The road was constructed. But, my lords, the final award never came to pass. And it's only in 2021 when the writ petition was filed. And the second thing we had in
No, but whether the award was passed.
tentative award was passed in 2012.
Then the law has to take its own
Yes,
course.
my lords are right, my lords. We can, my
The law
lords.
has to take its own course.
My lords, your lordships did that judgment. My lords, we found one judgment where your lordships had there was a diversion of opinion, my lords, of two honorable judges of your lordships court in a matter where, my lords, the question was whether urgency clause is invoked, whether, my lords, automatic lapsing is there. So larger bench answers the question of law against us in this case. They say that it will apply and lapsing unless 80% amount is paid and the final award has been made, my lords, it cannot be saved. The law has to take its course. But kindly see para 24 of this. Your lordships my lords, in the peculiar facts, did, my lords, assist us in that case also. May I please para 24? The law is laid down that it will lapse. But then 24, in the normal circumstances, acquisition would lapse insofar as appellant's land in view of a conclusion on the legal aspect. However, in the fact situation, relief is required to be modulated. It's for the reason that land belonging to the appellant is not a standalone extent. As noticed, acquisition was for a planned industrial layout. Total extent acquired in possession taken was so and so. Land belonged to appellant is only so much out of this. In the planned layout, land has been utilized for various purposes and amenities. Mandi has been constructed over a large extent of land, which is smaller extent of land belonging to appellant also forms part. The reversion of the land does not, the question of reversion does not arise. Further, the course has suggested in Lakshmi Devi to issue a fresh notification also would not be appropriate since the very scheme of acquisition and determination of compensation under the old regime has
At least the award was passed in that case. Here the award is also not passed.
The only tentative award is there, my lords, in this case. But, my lords, these are the only two things that I can urge. Otherwise, my lords, this case has 29 landowners, only 13.
For the new act,
As per the new act, my lords, it will come to about 19 crores, my lords.
and how much was under the tentative award?
1 crore 75 lakh.
1 crore 75 lakh.
And 25% of that was paid, my lords, which they agreed.
How much you are willing to pay?
My lords, your lordship may put us to terms, and then, my lords, I bow down, my lords. The lordship will also permit us to recover it from the.
The 5 crore deposit eligible. Srimati Bhatti, the learned ALJ, appearing on behalf of the petitioner, states that the impure order came to be passed on account of an erroneous communication of one of the officers of the state. She has placed on record a copy of the government order dated 26th of March 2025, by which the government of Jammu and Kashmir has constituted a committee as to inquire into the conduct of the officers who were responsible in delay of the land acquisition proceedings. In the peculiar facts and circumstances of the case and in view of observations in para 24 of the judgment of this court in the case of D.EL.ED Services Private Limited versus State of UP and another, put it so and so, we are inclined to issue notice. Issue notice. As you file a contempt,
Contempt is going on.
issue notice, returnable, 4 weeks. And there shall be stay to the contempt proceeding on the condition that the petitioner deposit an amount of rupees 5 crores before the land acquisition officer.
Please, my lords, or your lordships court, as your lordships be.
In this court on deposit of such amount. This said amount be deposited within 4 weeks.
My lords may consider 8 weeks, sir. 5 crores was a big amount.
5 crores from government, what is it?
My lords, we don't want to default and then come, we'll try to do it as early as possible.
6 weeks kar den. Notice returnable 6 weeks kar den. On deposit of the said amount, the said be invested in the fixed deposit receipts for a short period. Thus be permitted. This is only tentative amount. You may
I found no money.
try to find out some viability. 916 days delay.
My lords, we actually tried to, my lords, take the action, but then when we calculated, it was a huge amount, my lords, so we deemed it that we should come before your lordships.
I appear for the respondent in the matter.
We have already issued notice in the connected matter, madam.
Lord, in the connected matter, Lords, it was filed by persons who are also seeking similar relief. So there was no challenge to the decision. Your Lordships had in fact said that your Lordships did not want to grant stay because, Lords, these people have been waiting for the last 10 years, and after 2017, when the selection process was fully completed, Lords, they rely on a subsequent policy of the government. Your Lordships will kindly see page 391.
Okay, then let him come.
Obliged.
Awesome.
Yes, the lordships, this petition is raising a very pressing concern regarding.
Yes, but it's a policy matter. You ask your parliament. It's
My
to
lords,
the next
my
law.
lords, we have already sent several representation. In fact, the digital personal data protection rule has some provision, but what that provision says that there has to be some parental supervision. So this is not an issue about parental supervision. We need some strict age verification mechanism here, my lords, because
We are not inclined to attend in the present.
my lords will then allow us to make a representation.
One minute. In as much as the relief sought is within the domain of policy. Very good. We therefore dispose the petition with liberty to the petitioner to make a representation to the respondent authority. If such a representation is made, the same would be considered in accordance with law within a period of 8 weeks from the date of receipt of such a representation.
Similar SLB state were already dismissed.
Yes, thank you.
16 and 19, delay mallards may kindly.
Delay control, dismiss. 19 all.
Restoration application, my lords. Counsel.
Twice on 2 days you are absent.
He was unwell, my lords. Yeah, he was in, because of the lung infection, he was not in a position to attend the court.
But he could have told someone.
Some mistake on his part, my lords, kindly condone the same, my lords. 2 other SLPs is coming, sir.
What about merits?
On merits, my lords, whole family has been dropped in, my lords. Lordship are pleased to issue notice in the first matter. It's an after notice, madam. I'm grateful. I'm so sorry. Grateful.
Number 133 the only request I made is I have the original documents. I wish to produced before the High Court. And then earlier remand was not by me. That was somebody else approached the High Court and it was demanded. Everybody got this.
You did not challenge the earlier, in the earlier round, the order of the trial. So therefore.
Challenging that because when it was set aside, the decree.
But did you challenge the first judgment of the trial court?
Yes, it was challenged.
By you?
Not by me. But
You accepted that judgment.
now what has happened is, the item number 1 and 5, that was just said, Basama, my mother, are sole absolute owner. And now she died, it has to be divided by 1 by 8. There are 8 children. Now what has happened, in this item number 1 and 5, I have she has executed a gift and a settlement deed. That matter I could not produce. You also can say I have it documented.
Okay, Mr. Mali, thank you, sir. Sorry.
What happens?
Sorry.
House where it will be. Also kindly, I just permit me to read paragraph 26 for a moment. I just I leave it then 26 and 27.
Yes.
Of the appeal order. It starts at page 28. It is proved that house property bearing door number 47 married.
This.
6. It is proved that house property bearing door number 4798 measuring so and so were not executed to anybody else through settlement deeds or deeds and the original plaintiff Basama retained herself. Therefore, the trial court is correct in declaring that original plaintiff Basama is the owner of the property and she died in the year 1999. Her 4 daughters and 4 sons are entitled for 1/8 share in the above stated properties is found to be correct. I am not disputing. The trial court by molding the relief in this regard as partition the property which cannot be said otherwise or illegal mortgage. Now considering the application filed in RFA, number 1, this is my 133 of 2023 for production of additional evidence by defendant number 8. The document produced as Xerox copies of registered deed, gift deed, settlement deed.
So you have also got a share as per the.
As per the degree, I will get
1/8, yes.
But because of this document, partition, deed and settlement, I have original document. But this is absolutely given to me. Now I will be out of this the property where I am deciding.
Thank you. Delay control this.
Both of the principle of law will that I must first face the prejudice. A loss and then go to High Court to challenge the statutory regulations saying that they are violative of fundamental right is contrary to a lot of place the judgment state of evidence. And in fact, also I showed it's not an apprehension of prejudice, it's a prejudice today. Not my colleges are being tested and examined based on today's regulation.
The learned division bench has laid on the celebrated judgment of Chiranjit Lal.
That doesn't apply. That was one shareholder who challenged the ordinance. The company didn't come. Your lordship held that it is not his right how company is to be managed.
It shows the rule.
Yes.
The dominant rule.
There are several rules. We challenged about 30 regulations. The regulation begins at page 258.
Shows the one which you did you worst.
Yes. I like. Can I just first put the general notes to show that why High Court is wrong? Yes.
It shows the regulations now.
I prepared a table also of the. I gave that.
Which paragraph you are?
Yes, just 2 paragraphs. Notes. Here an ordinance was challenged. Notes. And kindly notes turn to note para 10 notes. 10, 11 and 12. May I please? The present petition under 32 have been instituted by an association of Archaks of Chinakshi Amman Temple of Madurai. The writ petition was filed challenging government order number 2 and ordinance number 2, which at the time had not come into effect, as the amendment of section 55 made by the ordinance had not been continued by the amending act. The said part of the challenge made in the writ petition became redundant. Now, para 11. Preliminary objections have been raised by the maintainability of the writ petition by the government, appearing to the respondent. It has been urged that the present writ petition have not been filed as PIL, and in absence of any specific orders in implementation of the MPO, the writ petitions are premature. Now, this is rejected in para 12. it is difficult for us to accept the contention advanced on behalf of the respondents with regard to maintainability of the writ petitions on two counts. Firstly, it is difficult to appreciate as to why petitioners should be non-suited at the threshold, clearly because GO has not been given effect to by actual orders of the state government. The institution of the writ proceeding need not await actual prejudice and adverse effect and consequence. An apprehension of such harm, if the same is well founded, can furnish a cause of action for moving the court. So this is the law. Because I saw the 50 judgment also. 50 judgment came at instance of one shareholder saying that I hold one share in some company, challenging an ordinance, which ordinance sought to provide better administration for that company. The company never filed a writ petition. Now, my lord, on fact, my lord, unfortunately, High Court doesn't go, my lord. High Court only touches one regulation of the 30 which I challenged. And that regulation doesn't have a timeline. And it's not a question of timeline, my lord. I'll give you two examples. They want, my lord, biometrics, my lord, of every student to be recorded when they enter the college.
Show those regulations.
Yes. Kindly have the chart. So just give one, my lord. PC2. Aadhaar enabled biometric attendance system and CCTV surveillance.
So what is wrong in that?
Yes, Lord, I just made a comment. Lord, then this ground has to be tested. I may fail. Today, High Court says I will not consider it till somebody comes and says you are not complied with it, therefore we will not give you renewal. Today, that's the problem, my lord. The High Court has not tested it.
3 minimum teaching staff required. What is wrong in that?
I'm sorry, Lord.
3 is minimum teaching staff.
Yes, I will tell you also what's wrong. Can I just complete two, my lords? Compliance of this regulation would infringe the rights of students, more particularly in OPD and PC labor routes, and also in case of minor students without consent of their parents. And the total cost, lords, which will have to be recovered from students per college average annually is about addition of 1 crore rupees. Now, please see.
Per student?
No, per college.
Per college, so you will get it when the fees are determined by the. You can factor in that.
That's one of the things, Lord. Today, Lord, what is it that I am requesting your lordship? That my challenge has to be, Lord, considered either allowed, disallowed by the High Court, Lord, consideration of the regulation. High Court today non-suited me on the ground that I am premature, and I have shown the Lord prima facie, Lord, on basis of your lordship judgment that I am not premature. But look at 3 lords to satisfy your lordship. Your lordship said by minimum teaching. I have a minimum teaching staff regulation. These are colleges established from 2002. And from 2002 to 24, my lord, I have renewal every year. So it is not that I don't have.
Also, therefore, if on this grounds,
yes,
your continuation is rejected, then you may have a claim.
It is bound to be rejected, number one, my lord, because according to me, these are not required to be fulfilled. Question is, can I go to the High Court today and say that these are not required to be fulfilled? High Court says no, and I am saying it is contrary to your lordship's law. That's the point, my lord, on which I have come up to Supreme Court. Now, my lords, what is Can I show you what is wrong in the regulation?
You have seen the regulation.
So there are 30 of them, right? Just
we have seen the entire chart. You do not find a single one of them to be so arbitrary or capricious.
So that would be a decision.
If you want, we will decide it in reversal.
The option has been given to you there. And then when it happens,
what happens is, can I just put an alternative prayer?
Yes.
Call it Lord. Today, Lord, inspections have taken place. They are, according to our reading, Lord, of the regulations, they are bound to reject it.
No, you can't have such apprehension. You can't. You will say that I am going to apply before the High Court for bail, and the High Court is bound to reject it, and therefore grant me bail.
Not High Court.
It's like this.
Not High Court. I'm sorry.
No. You know, you are talking about the body, the regulating body.
Now, Lord, when they reject it, Lord, I go to High Court. By the time it is decided, Lord, the year is gone.
High Court would not be that sensitive that all the colleges would be permitted to be shut down.
21 lords in Ayurveda, lords, about 12 or 15 in homeopathy, lords, and similar regulation. Lords, one of the regulations.
High Court won't be that sensitive to permit 21 Ayurvedic and 12 or 13 homeopathic colleges to be shut down.
The High Court lords could have. The High Court could have simply said, I looked at the regulations, prima facie.
We have prima facie looked at the regulations.
Then your lordship may not say that. If your lordship say that, what happens to my challenge?
Yes, therefore, should we dismiss or do you want to withdraw? The choice is yours.
I withdraw in view of the liberty granted.
The learned counsel of the petitioner seeks liberty to withdraw the petition in view of the liberty granted by the High Court. the approach at the appropriate stage.
Okay. Well, I'm requesting for a passover.
Initially, there was a conviction against me, acquitted by the High Court by a well-reasoned order. This Honorable Court remanded it back. This time, my lords, it has come with on the same set of evidence with a reverse conviction.
Oh, ma'am. Mr. Kousik, I did now. 520.
I'm sorry, my lords. Sorry, I started. May I, in the meantime, just sorry.
One of the sons has been fired in the presence of the complainant.
Right. Now I will show.
The other, when he goes to home, we found that he is also
entirely unbelievable evidence. That is one. I leave that aside. I'll come to the major point. My major thrust today is this: that the defense witnesses, there are about 6-7 independent defense witnesses, including one DSP who has given me a clean sheet. I was named in the FIR, given a clean sheet after that. Closure. FIR, the judgment records that. In column 2, they said that nothing found against me. That DSP's testimony, not a single defense witness's testimony has been considered in the impugn order, quite apart from the fact, and please note this, that the judgment of the impugn judgment for this incomprehensible. What can I say? I didn't want to go there.
At least my learned brother might be in a position to understand something that's in the company there. So, but
the word defense witness is not found in the impugn order, and
show us one of the
so many days there. Now, please
show us one of the defense witnesses.
Please see the additional documents that I have filed, which has the defense witnesses. I will start with DW1, or may I just take your lordships to the earlier judgment of the High Court, detailed 2-3 pages, and that's all. May I just take your lordships? Please see 123, the earlier judgment, detailed judgment of the High Court, which was set aside by this court, by an order saying that you reconsider it. Perhaps, my lords, on the same sentiment that 2 sons have been killed. Now, my lords, please see at 111, 112.
We don't decide by sentiments.
I know. 112 is where it starts. 123 onwards is where I am relying upon. And the thrust is on page 129. Just these 2-3 paragraphs, and that is it. There are witnesses who say that we have seen that a person who, in a muffler on his face, has come, shot and gone, single person. Entire prosecution story is this, that 3 people came, including one which is the petitioner, in a car, 129. Please see 129. Lordships have that of the SLP paper book. A number of witnesses have been examined in defense. They have stated that a person, muffled face, had fired at Balkar Singh and then ran up. One singular person. Arjit Singh Brar, DSP DW1, who had supervised the investigation, found appellant Jaswinder Singh, which is myself, innocent, and put him in column number 2 while presenting the challan. Similarly, Varyam Singh, DW2, had stated that Tata Mobile, now they said that I had come in a particular car belonged to DW2. DW2, comes to the witness box, says that I have not given them my car. Similarly, Varyam Singh, DW2, has stated that Tata Mobile was not used by the appellants and he is the owner of the vehicle. Joginder Singh, DW3, Amarjit Singh, DW4, Resham Singh, DW5, Kashmir Singh, DW6, Joginder, so and so, who are neighbors, have categorically stated that the appellants did.
Notice. I'm very voice. Just to commit it. Everybody will saw the standard.
Notice on the stage. Very great.
Notice on this.
I'll just point out one other thing. When we came to this honorable court, in the SNP, there were 2 parties, 2 petitioners. The second person did not surrender pursuant to your lordship's direction, but we have deleted him. We have no this thing. The office report also records that my
you surrendered.
I surrendered. That's why I'm asking you.
There are 2 appeals.
Two separate petitioners. One petitioner has been deleted. That other appeal pertains to him. So I am not for that. I'm only, the office report speaks for itself. The office report is very clear. I'll clarify. He is deleted from the array of parties. Only for the petitioner number 1. Office report. As per the in terms of the office report.
No, but there are 2.
Because there were 2 petitioners originally. One did not surrender. Therefore, we said that we have nothing to do. Delete it. He was deleted. Only 1 person. Very grateful.
My lord, the petitioner is a introducer. He had
Is a
introducer. He is an introducer. He has introduced a person.
introducer.
A person Pradeep Kumar Sharma to open an account.
That Pradeep Kumar Sharma has not been found.
And his case is covered by Manoranjan Das versus State of Jharkhand and others.
Issue notice.
My lord.
4 weeks. Huh?
So this is a challenge, my lord, where the High Court has reversed the conviction, my lord, of AO2, wherein, my lord, there was categorical evidence of PW1, who is the complainant, that AO1, who passed away during the course of the trial, my lord, had taken PW1, the complainant, my lord.
What to defend it?
My lord, there is delay, my lord.
And not. In the other matter also you are there?
Yes, my lord. 25 months.
25.
25 is the person went to a lodge, my lord. They took the money despite.
In one matter you are for CBI, and in the other matter you are for Telangana.
Both are statement, ACB matter.
It should be noticed.
And most delay in both matters. Most.
Already this SLP has become instruction and the press something order has been issued by the Recruitment Court.
The learned counsel petition states that by the petition is rendered infructuous, dispose of it.
Lordships, the complainant herself in para 7 of the FIR admits that there is a civil suit pending between the parties. Her main grievance, Your Lordship, is that on the basis of a cancelled will, my will.
You have been using it even after cancellation.
Please, my lords.
Our grievance is that
Please, my lords.
the will was cancelled by the executor and a fresh will was executed.
Please, my lords.
In spite of that, you are acting as if the first will is in existence.
Please, my lords. That's the allegation. However, my lord, she has concealed in the FIR that before she filed the civil suit and before the FIR was lodged, the patta was cancelled by the Jaipur Municipal Corporation themselves, finding that there is a, kindly see the cancellation order. I'll just read 2 pages, Your Lordships, which is on page number 104. Lords, page 104. This is 20th November 2023 order passed by the Jaipur Municipal Corporation cancelling her patta. You had submitted application in Municipal Corporation Jaipur on dated 2nd June 2020 to obtain bill dated 17th March 2020 of late Sohanlal Sharma and other documents. Please state Municipal Corporation, considering the documents submitted by you correct, had on dated 20th July 20 issued lease of plot house number H67 so and so. After the above proceeding on 13th September 2023, Sri Suresh Tandela submitted application before the Honorable Commissioner, Municipal Corporation Jaipur Heritage, revealed this fact that the bill dated 17th March 20 submitted by you is forged, in connection with which Sri Suresh Tandela has submitted SFSL report dated 25th April 2022 issued by State Forensic Science Laboratory, Rajasthan, in which in the bill dated 17th March 2020, which has been issued in favor of Sangeeta Sharma, the signatures of late Sohanlal Sharma have been found to be forged. Besides this, in connection with this very will, one first information report 17/2021 dated 11 January 21 is registered against you at police station so and so. So, Your Lordships, on the basis of SFL report.
What is the relationship between you and us?
Your Lordship, actually Sohanlal Sharma virtually had no relation with anybody. In the bill also he says that I have no family. So Suresh Tandela, my client, used to take care of him. There were virtually almost 50 properties which belonged to him. So he executed a will in my favor and Sohanlal died on 29 February 20, whereas the will on which the complainant is relying upon has been executed just a week before on 22nd February 2020 and which was got registered after his death on 17th March 2020.
Issue notice.
Your Lordships may kindly stay the proceedings as well.
We have the proceedings for the trial court.
In this case, after she received the amount of 1 crore, in this court, she goes and files 2 cases in the US
and then she seeks an injunction from the US court that please stay the proceedings in the Supreme Court of India. After receiving 1 crore for herself and the minor child, please have order of 1st of May. Because I filed an application 296423 of 2024. After pursuant to an order of your lordship of 1 crore, full and final settlement of the wife and the child. And that was paid into 2964, diary number 59588 of 2024.
Lordship, I have filed my
MA, sorry,
statement
MA number. Sir, MA
before the Honorable Court.
MA number.
The petitioner wants to discharge in this matter and
He wants to discharge, I think.
Can I continue? Lordship, I filed my written statement on the record and the petitioner wants the discharge on the basis of the false allegations. She used the term unprofessional in the NOC application and also in the discharge application. I totally object and oppose this. I filed my statement. In such circumstances, I can't. And please see my written statement which I filed before this. Now, Lordship, it becomes the fashion to go to the false allegation to get the NOC and then attemptedly fight the discharge application. And being the officer of this court, it's my duty to inform before the honorable parents.
The facts have not been represented properly.
One minute.
That's why
I filed my wakalatnama and also appeared and argued for the party on the last date and got the dates for the party. Then how can they blame in such a? If they want NOC, then they should come in the proper manner. Not the false allegation. How can they use the term unprofessional? That is a big deal, sir. In NOC and also in the discharge application, they give 2 times reference the unprofessional. And they also mentioned that the commitment. I never made any commitment to anyone. How can they force me to do the work in the free of cost? How can they make the pressure on me in such a way? Sir, it is the fashion and the new tradition. And
where is your statement?
Sir, it is on the record on 18th of March. In the office report, it is also mentioned, sir, in my statement. One-page statement, sir. I am just here to oppose this word and this statement, sir. And in such circumstances, I do not want to continue.
If you want to do a discharge, you should have sought for a discharge.
Sir, we have requested him to provide the NOC. He did not provide it, and the coordination was not done properly.
In that the word used, they use the word unprofessional. How can I accept such type of thing?
Sir, he did not lift the phone. He did not reply to the mail.
They are putting all the things wrong because Lord said, I do not want to say in the open court, but they are using the on reports and also abusing the process of the court. They want to linger on the case by changing the on reports frequently.
You better get yourself looked at. Yes. Why do you?
Oh, that's why, sir, please.
Correct. The petitioner has filed an application for discharge of the award Dr. Vivek Sharma. Correct. Dr. Vivek Sharma states that in view of the objectionable language used by the petitioner in the application. He himself does not seek to continue with the present matter. The petitioner ought to have been cautious enough to use the words in the application for decision. In any case, since Dr. Sharma does not want to continue in the proceedings on behalf of the petitioner, he is discharged from his affidavit.
In the main application, page 12 is the order, first order.
Page application number?
The one, MA 59588.
Page
12. It was the first order passed by your Counsel on 1st of May 2024, page 12. Lord has page 12.
Yes.
First May order. Mr. Anand Dalip Mande, Learned Counsel appearing for the wife, submits that the appellant is willing to settle the matter if the respondent husband pays an amount of rupees 1 crore as one-time maintenance for her as well as her son. Mr. Ditne appearing for the Johar appearing witness, he is willing to pay 50 lakhs. However, taking into consideration the status of the respondent husband and his earning, we find that an amount of 1 crore would be a reasonable amount, and I was directed to place an affidavit of undertaking. Now, please see page 14 and page 15. I place that affidavit on record, and my lords, at page 15 I say that there is a divorce decree passed by the US court in para 4, and I am willing to pay this amount as lump sum within the time frame your lordship has submitted, and my lords, thereafter there will be no cases against each other. My lords, I say that I will pay in full and final settlement, and that time my son was about 17 years old, who is now standing in court, my lords, today. Then, my lords, after that, there is another order passed by your lordships on 15th of May at page 18, my lords. That is at page 18.
Yes, you have seen those orders.
Yes.
Finally, page 21, 22.
Yes, yes. And then your lordship also said that I have to pay in 2 installments, and then 1710 I paid it. My lord, 1710 the matter was disposed of because the High Court had crossed the FIR against me and my parents by 2, and they had come in appeal. And in here we said, okay. Now, my lord, what happened is on 6/10/2024, after having received the amount of 39, she files a petition in the US court saying that I should be granted more alimony. Your lordship will see that petition in the US court. First, she abandons the US court, does not send the child back to US as per the order of the US court for so many years. That order is being passed on 5th of October 2012. And now what she does is, after receiving the amount of 1 crore, that petition from her page starts from page 20.
She is residing in US or she is residing in Hyderabad?
Yeah.
She is a lawyer also.
Yes, she's a lawyer. She was the president of Warangal District Association, also the wife. She is present in court today. My lords, the petition starts from page 23. Now, please see page 36. The prayer she makes in the US court after receiving the amount of 1 crore. Page 23, it starts, page 36. Para 7. Grant permanent child support and financial alimony in the event that the divorce is deemed valid. Order the respondent to provide fair and permanent child support for Siva Kumar Thotapalli and financial alimony for Padma, that is her. And, my lords, she also admits that she has got 1 crore at page 28. Please see page 28, para 2. Financial payments in dowry case, she says.
You should have been careful enough at the stage of passing order. You should have insisted on an undertaking from her that she will not.
I thought that then order clearly said that it is for her. Now there is a judgment of Justice Pardiwala also, which says if a lawyer gives a statement on behalf of the client, even contempt can be issued against the client. Now she has said that she is taking for herself and the minor son 1 crore. I said I give 50 lakhs, but your lordship insisted upon us. We paid that amount.
Yes.
Yeah, Your Honor, the point is that there have been only partial indications which were there, and that was before the marriage, the dowry case, and after the marriage, the 4 years of the harassment was only mentioned in the criminal matter. There was a lot more harassment which was done later, which also led to my 11th grade. I was unable to do my 11th grade because they did not provide my passport and the visa renewal. And I lost my 11th grade. I have only 3 years of college. And now, instead of 4 years of college, which is required, I'm lacking behind my 1 year of college education. Apart from it, the Honorable Courts 15/5/2024 orally said, which consisted yourself, Honorable Sandeep Mehta sir, and Honorable SV Bhatt sir told that the child issue will be taken later after the 1 crore is paid, which never really happened, and the case was closed abruptly. And now my life is at stake. And the amount which is given is not sufficient in terms of United States of America. And we have also.
Are you staying in United States?
No, sir. I want to go to the United States and pursue my education.
Are you willing to go and stay with your father?
No, sir. He is a pedophile. There has been clear allegation of by his own alleged wife in the United States of America that he is a pedophile, Your Honor. That is provided in the annexure also. There is a screenshot, Your Honor, in page 1 or 2. Is a screenshot of the alleged wife stating that he sexually assaulted his own daughter.
Your mother is his wife, first wife.
No, she is the wife in India, Your Honor, as per Indian context, and the US court divorce decree has also been, so family court have ordered the injunction over it, Your Honor, so it doesn't have any enforcement as per the context of India. And here, Your Honor, in using the American court order, they have stopped my mother's visa, they have stalled my passport since 2012. Until 2022, they did not give my passport. My visa got expired. I was kicked out of Kendriya Vidyalaya Sangathan, and because of which I lost my 11th grade, Your Honor. Today I stand here that my education is lost, my health was compromised. Because of, even in United States, because of this harassment, I was undergoing PSTD, post-stress and traumatic disorder for 3 years. And now because of the passport stress, my mother got 400 insulin fasting. Her nervous system is damaged, Your Honor. And I got melasma and hypopigmentation. I'm currently being treated with dermatologist with the conditions, Your Honor. After all this, what we require.
But the CA which ought not to agree for 1 crore. I mean, agreed for 1 crore.
1 crore is only this matter, Your Honor, because there were several other issues which were in place.
Can I just submit? He's not submitting the right thing.
But then how can we now inject the US court?
What she wants is, now she has asked for an IT suit from the US court. This amounts to contempt. I'll tell you, brothers. Having received, one more thing. They were married in 2005. He was born in the US in 2007. Now what they do is, both the mother and the son come on 3rd of March 2011. I filed the case in the US court in 2012 for him to come back. US court passes an order that the child be repatriated back to US. He doesn't come. Then I file a habeas corpus. Then I lose. Then I come to Supreme Court. I get some visitation. That's all I get in the Supreme Court. Now, when the criminal cases are quashed, she takes 1 crore. Now she goes to there and she wants an injunction against the Supreme Court. Now, she has filed another petition in the US court asking an injunction from the US court to injunct your lordships from hearing this case. That's Maloj I'm saying. And after receiving the 1 crore, she should not have received the amount of 1 crore. Either she deposits the amount of
Your Honor.
I'm sorry, Mr. What are you studying?
I'm studying the law currently. I want to pursue it in United States, political science, law, and.
If you want, we'll ask him for your education, but this is not the manner in which your mother should have conducted herself.
Your Honor, there is a small correction. The US court order is influential in India because they violated the injunction which is written in the annexure page number 31, Your Honor.
Okay. We'll issue a notice of contempt to her. Let her defend it. Very good. From the perusal of the record, to reveal that.
But he's a US citizen, Your Honor. He's also a US citizen, and because we got this settlement, we didn't have money, we have approached the US court now, Your Honor. Because that case was open.
Where is Mr. Lange?
He is not there, Your Honor. He was unable to present the facts. That's why we had to change our ticket.
They changed Mr. Lange, then she changed the second lawyer.
Because we didn't have.
Not have accepted that amount of rupees 1 crore.
Because we didn't have any financial support at all, Your Honor.
From the perusal of the record, it is clear that.
We have one humble submission. 15/5/2020.
Yes, sorry. Yes. You either withdraw those proceedings. If you are concerned about the son, we'll talk to him about his education. But you will have to withdraw those proceedings in the US. Otherwise, you are taking the court for a ride. Mr. Please, she's talking only one at a time.
That is stalled, Your Honor. The US court proceeding is currently stalled. It has not been taken.
Very good. After making a statement before the court that the petitioner was willing to settle the matter on payment of rupees 1 crore as a one-time maintenance for her as well as her son, the petitioner has now initiated proceedings in the US court for further maintenance. It has also filed an application in the US court for an injunction, seeking an injunction to restrain this court from proceeding further. We find that the conduct of the petitioner is highly contemptuous in nature. Issue notice to the petitioner as to why she should not be proceeded further for having committed contempt of this court and sentenced accordingly. When will you file your reply? We'll give you a date.
Within a week.
No, we are asking her.
Not a party.
Within a couple of weeks,
Yeah.
maybe 2 weeks.
Issue notice, renewal 4 weeks. If the better counsel prevails upon you, well, if the better counsel prevails upon you, well and good. Otherwise, will be.
The case has been stalled as a
Yes,
procedure.
otherwise, we are sorry. The maximum that we can sentence you is 6 months in some prison in maybe Warangal or Hyderabad. Better settle down. Insofar as education is concerned, we'll try to impress upon him that he should provide for his education, but not in this manner. And now, Mr. Johar should have insisted before payment of an amount that an undertaking should be. So we also now become wiser. Here and after, we'll have to be.
Some simple submission, Your Honor. The thing is, actually, we were told by our counsels that the court is now not going to listen to any of your plea. That's the reason.
Sorry, you'll file your reply, we will consider it. Date is enough. 4 हफ्ते के बाद का specific date is enough. Likely. Yes, Mr.
Judgment of the learned civil judge was reversed. The effect is this, take your lordships to the contention. Effect now is that about 42 persons will have to be appointed against non-existent vacancies, overlooking the seniority, going by the date of registration of 1,500 persons. And the court says that this will not, any other person who approaches the court will not be granted a leave.
Will not be?
Sorry.
Any other person?
No other person who approaches the court will be considered. No, my lord, the point is this, that if there are 1,500 persons, my lord, who are staying out, though they are more meritorious and their date of registration, the head of them to the writ petition, the writ petition was dismissed. And the contention was that the priority should be considered together. Court looked into the GU, court looked into the contentions of the teacher recruitment. The learned civil judge dismissed the writ petition. And in the writ appeal, my lord, the direction itself, court says, so there's a delay of 102 days.
Great. 31 is also same.
No.
What we did was, blood, for teachers' blood recruitment, instead of only the TET mark, we blood elevated the standard to have an exam. Now, blood, it is filed 5 years after the process has started. Now the High Court says from the current vacancies in 2025, he should give blood those people who were blood in the process and who were not appointed. But it's a matter of policy. Your lordships have always said we can elevate the standard rather than downgrading the standard.
Madam, we'll hear both these matters together.
Yes, Lord, if your lordship so pleases, because this is only a case where any short date, no, so because they've been, it's already pending for the last 10 years.
Tag कर देना दूसरा जो other side से आए.
Stay meanwhile, but we have been directed to appoint the current board.
Lord, let them appoint it subject to the result because the policy changed much later.
It stays stay of the order.
Lord, if
My lord, item 32, my lord. My lord, similarly situated accused or rather having lower role have been protected by the honorable court, my lord.
Notice the order get same order is maybe.
I am obliged.
Case of diversion finding, your lordship, the main suit is still pending. In fact, say,
What is the stage of the construction?
construction was okay. These are the photographs of yesterday evening, Marcus.
And you have already predicted that whatever construction is there will be subject to the result of the suit.
Already High Court has said, and
So
there is a delay of 220
if you succeed in the suit, you will have to demolish it. You are you are a doctor.
I'm no. Postgraduate.
And there are other properties wherein your claims can be adjusted.
If I can actually, I will not insist on that, Your Lordship. If Lordship's okay, see the observations that are made in paragraph number 10 and 11. My Lordships may say that as advocate deciding the suit itself. My Lordships may say that the observation made.
We are not inclined to enter in the present petition, since it arises purely out of an interlocutory order. In any case, the interest of the petitioner is protected by the appellate court by observing that the construction shall be subject to the result of the suit. Very good. In the pattern circumstances, we dispose of the SLP by directing the trial court dispose of the suit expeditiously. So we further clarify that the learned trial court, while deciding the suit, would not be in any way influenced by any of the observations made by the learned trial court, either by the learned trial court, while granting injunction, or by the appellate court while reversing the same.
Specifically open for us also, because my Lord Sir said it will.
You have said that we are now with neither of the observations.
Yes, ma'am.
Specifically in paragraph number 10 and 11, as if it's deciding the actual suit against me.
You have said any of the observations. Why do you want to restrict it to para 10 and 11? So I'll ask him to join. Ask him to join.
My lord, I'm appearing for the applicant, my lord. I'm so sorry, my lord. I was available, my lord, but I could not be joined, my lord. My lord, this matter is basically arise out of second appeal passed in the 27th of August 2004. My lord, there is a huge delay.
The learned judge who has decided the matter
Correct.
would be demitting his office.
No, my lord, what I request is, my lord, that there is the issue which is pertaining to the extra portion of land, my lord.
Dismissed.
No, my lord, I request my lord to allow me to withdraw with liberty to, my lord, allow me to withdraw with liberty to approach, my lord. The only prayer is that, my lord.
Allowed to withdraw with liberty to take such steps as are permissible in law.
Oblige, my lord.
It's 31 दोनों के साथ दोनों एक साथ
with regard to the condition of this problem, that was never, my lords, an issue. The suit filed by me has been rejected, my lords, on a 7th.
While granting stay, the appellate court is always entitled to.
So, my lords, when the 7-11 application was allowed, my lords, without any prayer, without any evidence, the learned single judge has granted mean profit. I have challenged, my lords, there is no evidence at all to show that this mean profit is even at one.
Challenge, the order is also of eviction.
That's right.
So your position is protected.
Just indicate, mean profit in any event, my lords, there has to be some immediate to that effect and some prayer to that effect. That's not.
Sorry.
My lords, may there be one request. Would my lords, there was some time granted, 1 month's time granted. Kindly grant me another month's time.
We are not in.
Division bench for modification.
We are not inclined to enter into the present petition. When we express our inclination to enter in the petition, Sri Mandiyal, the learned senior counsel seeks liberty to withdraw the petition with liberty to make an appropriate application before the High Court. Dispose of it.
This is for an extension of
we further direct that the period granted by the High Court for deposit of the amount shall stand extended by 6 more weeks from today.
Extremely.
Lordships, may I mention item 27? The Lordships have issued notice in past stay orders. If the order can be given today, just a humble request.
आपको बता दे रहा हूँ